My mom called me the morning after the verdict and said, "We got the house back. It's over." She sounded like she'd just won the lottery. I listened to her voice, bright and triumphant on the other end of the line, and I said, "Congratulations, Mom." Then I hung up and sat very still at my kitchen table for a long time. She didn't know what I knew. Her lawyer didn't know either. Not yet. By the time he figured it out, it was too late for all of them. But I should start from the beginning, because none of this makes sense without the years that came before it. And there were a lot of years. More than most people would have survived with their sanity intact. I'm not saying that to sound dramatic. I'm saying it because by the time my mother called me that morning, I had already let go. I had already decided that the house, the land, the history, all of it was worth less than the weight I'd been carrying. What I hadn't told her was that letting go doesn't mean walking away empty-handed. Sometimes letting go is the most deliberate thing a person can do. My name is Claire. I'm 41 years old. I grew up in a small town in central Ohio, the kind of place where everybody knows your name, and half of them know your business before you do. My parents, my mother, and my stepfather, Gerald, owned a property on the edge of town that had been in my grandmother's family for 3 generations. It wasn't a mansion. It was a farmhouse with 4 bedrooms, a wraparound porch, 11 acres of land, and a barn that hadn't housed animals in 20 years, but still smelled like hay on warm afternoons. My grandmother left it to my mother when she passed, and my mother and Gerald moved in the year I turned 17. I never lived there as an adult. By the time the house became my mother's, I had already left for college, then stayed gone the way young women do when they sense that going back means getting stuck. I loved my mother. I loved the house. I just didn't love them enough to trade my life for proximity to them. So I built my own life 3 hours away in Columbus. I became a paralegal. I got married, then divorced, then quietly rebuilt myself into someone who didn't need anyone to tell her she was doing fine. I knew I was doing fine. Then, 8 years ago, Gerald had his first stroke. He recovered from that one. He was slower afterward, a little foggy in the mornings, but he could still drive short distances and manage the yard. My mother was 63 at the time, and in decent health, though she'd started having trouble with her knees. They were fine, mostly fine. The kind of fine that requires frequent phone calls and occasional weekend visits, and the low hum of worry that never quite goes away when your parents are aging and living on 11 acres 3 hours from you. The second stroke, 2 years later, was worse. Gerald came home from the hospital needing a wheelchair part-time, full-time assistance with bathing, and medication management that my mother, who had never been organized about anything, was completely unprepared to handle. She called me from the hospital waiting room on a Tuesday afternoon and she was crying so hard I could barely understand her. I drove up that night. I took a week off work. I handled the discharge paperwork, the home health agency intake, the prescription coordination. Then I drove back to Columbus and spent the next 6 months doing that drive almost every other weekend. It was during one of those visits, about 8 months after Gerald's second stroke, that my mother sat me down at the kitchen table, the same table where I'd done homework as a teenager, the same table where my grandmother used to roll pie crust on Saturday mornings, and she told me she was drowning. Not her words. My mother doesn't use words like that. She said, "Claire, I just don't know how much longer I can keep up with all of this." And then she pushed a stack of papers across the table toward me. Utility bills, property tax statements, a notice from the county about delinquent maintenance fees on the drainage easement along the back of the property, a letter from Gerald's insurance company about a billing dispute she hadn't responded to in 4 months. I looked at the papers. I looked at her. I said, "How long has it been like this?" She said, "A while." It had been a while. The property taxes alone were 18 months behind. There was a lien on the house from a contractor who had repaired the roof 2 years earlier and never been paid in full. The drainage easement, and this is where I should have paid closer attention, though I understand now why it didn't register, then carried a mandatory maintenance obligation that was tied to the deed. It had been there since the county expanded the road on the eastern edge of the property in 1987. Every owner was required to maintain the drainage channel and surrounding vegetation twice a year or face county-imposed remediation fees. My grandmother had always done it. Gerald had done it for years. And then Gerald had 2 strokes and nobody did it. And the county had been quietly adding fees to the property record for 14 months. I didn't fully understand the scope of all this at the time. I was looking at my mother's face, which was exhausted and ashamed, and I was doing the math on what it would take to stabilize their situation. I was also, in the back of my mind, thinking about the fact that I was a paralegal. I knew how to read documents. I knew how to make phone calls. I knew how to negotiate with county offices. These were skills I had that my mother didn't. And the house, the land, was my grandmother's. It was my history, too. So I said, "Let me help." What I meant was, let me make some calls. Let me look things over. Let me spend a few weekends getting this organized. What actually happened was, I became the de facto manager of everything. Within 6 months, I had paid off the roof contractor lien out of my own savings. I had negotiated a payment plan with the county for the back taxes and was contributing to it monthly. I had contacted the county drainage office and scheduled the mandatory channel maintenance, which I paid for and supervised myself. I had organized Gerald's medical billing, recovered almost $4,000 in insurance overpayments, and set up automatic prescription refills through a mail-order pharmacy to reduce my mother's coordination burden. I was driving up at least once a month, usually more. I was spending money I hadn't budgeted for. I was spending time I didn't have. And somewhere in the second year of all this, my mother said something that I think she meant as an expression of gratitude but landed differently than she intended. She said, "You know, maybe it would make more sense for the house to be in your name. That way you can handle things without me having to sign everything." I want to be clear. I did not ask for this. I did not suggest it. I did not maneuver toward it. My mother brought it up, and when I said we should think about it carefully, she said she already had, and she thought it was the right thing. She said, "You're the one doing all the work. You should have something to show for it." We consulted a real estate attorney. We transferred the deed, the house, the barn, the 11 acres including the drainage easement and all its associated obligations became mine. I want you to remember that last part, the drainage easement and all its associated obligations. For 3 more years, I kept doing what I'd been doing. I paid the property taxes. I scheduled the easement maintenance. I kept the insurance current. I renovated the bathroom on the main floor so Gerald's wheelchair could fit. I repaired the barn roof when it started leaking. I planted the backfield with a low-maintenance wildflower seed mix because the county had cited the property for overgrowth twice, and I wasn't willing to pay a landscaper every other month. I drove up. I managed. I paid. My mother and Gerald continued to live in the house as they always had, because that was always the arrangement. The deed transfer was administrative, not eviction. They were my family. Of course they stayed. Gerald passed away in the spring of the 5th year. My mother grieved deeply and quietly, which surprised me. They had had a complicated marriage, but she had loved him in her way. I took 2 weeks off work to stay with her. I handled the death certificates, the estate paperwork, the notification of benefits agencies. I arranged the small service. I was the only one there who knew what to do, so I did it. And then, something shifted in my mother. I don't know exactly when it happened or what caused it, but over the following year, she became different with me. She started making comments about the house, little remarks at first. I was talking to my friend Dorothy, and she asked whose house this was, and I didn't know what to say. And, you know, Gerald always meant for this to stay in the family, and I've been thinking that maybe the arrangement we made wasn't really fair to me. I tried to have the conversation directly. I said, "Mom, you came to me, asked me to take over. I've spent 5 years and more money than I want to count keeping this property stable. The arrangement was your idea," she said. I didn't understand what I was signing. I had heard those words before, not from my mother, but in documents, in depositions, in the early stages of disputes that are heading somewhere no one wants to go. I called my attorney friend, Denise, and told her what was happening. Denise said, "Claire, you need to document everything. And I mean everything." I already had, not because I suspected this was coming, but because I am a paralegal and documentation is how I move through the world. I had receipts. I had bank statements. I had the county maintenance records with my name and payment confirmations. I had the contractor invoices. I had the email chain from when I'd discussed the deed transfer with my mother, including the messages where she'd proposed it. I had the signed caregiver coordination agreements I'd put in place for Gerald's home health aides, which listed me as the responsible party and financial guarantor. I had everything. What I didn't have was any desire to go to war with my mother. So when she called me 6 months later and said she'd spoken to an attorney and she was asking me to return the property, I didn't yell. I didn't threaten. I said, "Mom, can we please talk about this before it goes anywhere legal?" She said her attorney had advised her not to discuss it with me directly. She already had an attorney. His name, I would later learn, was Richard Hollis. He specialized in estate disputes and had a reputation in the county for being aggressive. My mother had apparently found him through Dorothy's daughter, who had used him in a divorce. He sent me a formal letter within 2 weeks, claiming that the deed transfer had been executed under undue influence, that my mother had not been in a position to fully understand the legal implications, and that she was requesting the return of the property. I sat with that letter for a long time. Denise offered to represent me. She said, "This is winnable, Claire. You have documentation of everything. Undue influence is very hard to prove when the transferring party proposed the transfer herself in writing." I said, "I know." She said, "So we fight it?" I said, "Let me think." What I was thinking about wasn't the law. I knew the law. What I was thinking about was my grandmother. I was thinking about the pie crust on Saturday mornings, and the way the porch boards creaked in the third spot from the left, and the smell of hay in the barn on warm afternoons. I was thinking about what it would mean to win this fight, not legally. Emotionally, I would win the house and lose my mother entirely, and I would spend the rest of my life in a place that was supposed to feel like home, but would always carry the memory of what it cost me. I thought about what I actually wanted, and then, quietly and deliberately, I made a decision that Denise thought was insane. I called her the next morning and said, "I'm going to consent to returning the property." There was a long silence on the phone. Then Denise said, "Claire." I said, "Not because she's right, because I'm done. I've been paying for this house, physically and emotionally, for 5 years. If she wants it, she can have it, and she can have everything that comes with it." Denise said, "You understand what comes with it." I said, "Yes. Do you think her lawyer does?" Another silence. Then Denise said, slowly, "What do you want me to do?" I said, "I want you to let me consent. I want you to draw up the reconveyance as straightforwardly as possible. And I don't want you to volunteer a single word about the easement obligations, the maintenance schedule, the back fees, or anything else attached to that deed." Denise said, "We're not required to." I said, "I know." She said, "Claire, if they don't do their due diligence." I said, "That's their job. They have an attorney, a property attorney, representing a client in a real estate dispute. His job is to read the deed. His job is to understand what his client is getting." Denise was quiet for a moment. Then she said, "Okay, I want to be clear about something, because I think it matters. I did not hide anything. I did not falsify anything. I did not create a trap. Everything attached to that property had been a matter of public record since 1987. The easement obligation was recorded at the county courthouse. The maintenance fees were on the county's property record system, accessible to any attorney who ran a standard title search. The drainage authority assessments were public documents. None of it was hidden. All of it was findable by anyone who knew what they were looking at. Richard Hollis had one job. He had one job, and he either didn't do it, or he did it carelessly, and what happened next was entirely a consequence of that. The legal process took about 4 months. My mother had filed a formal claim. I had agreed to return the property. The hearing, in theory, was a formality the judge needed to review the terms of the reconveyance, confirm there was no coercion involved in my consent, and approve the transfer. My mother and Gerald's daughter from his first marriage, who had inserted herself into this situation somewhere around month 2, sat on one side of the room looking satisfied. My mother was wearing a blue blazer I'd never seen before. She looked like she was going to a luncheon. I sat on my side with Denise and said almost nothing. Richard Hollis presented the case for reconveyance. He was smooth, confident, clearly accustomed to courtrooms. He outlined my mother's claim, noted my consent, and submitted the proposed transfer documents for the judge's review. The judge looked at the documents. She was a woman in her late 50s with reading glasses on a chain, and the particular stillness of someone who has seen every variety of human foolishness. She reviewed the deed. She reviewed the easement recording. She looked up. She asked Richard Hollis whether his client understood the obligations attached to the property. He said, "Your Honor, my client is simply seeking return of the family home." The judge said, "Mr. Hollis, I'm going to ask you to look at page 7 of the deed, the drainage easement addendum, and the associated county maintenance schedule." There was a pause. It was not a short pause. I watched Richard Hollis flip to page 7. I watched him read. I watched the particular quality of stillness that comes over a person when they are reading something they did not expect to find. The judge said, "Mr. Hollis, are you familiar with the county's drainage maintenance ordinance as it applies to properties within the Route 40 corridor improvement zone?" He said, "I'd need a moment, Your Honor." She gave him one. He used several. What Richard Hollis was reading, on page 7 and then on the attached county records that Denise had submitted as part of the standard filing, was this: the property carried a mandatory semi-annual drainage easement maintenance obligation. The maintenance had to be performed by a licensed contractor and documented with the county drainage authority. Failure to perform it resulted in county-imposed remediation at the property owner's expense, plus an administrative fee schedule that compounded quarterly. In the 5 years I had owned the property, I had performed and documented every required maintenance cycle. The property was current. The moment my mother's name went back on that deed, she became responsible for it going forward, and she became responsible for the outstanding county drainage authority assessment that had been accumulating since before I took over an assessment I had inherited and been paying down on a negotiated schedule, but which had not yet been fully resolved. The remaining balance, as of the date of the hearing, was a little over $22,000. It was secured against the property. It transferred with the title. It also meant that within 60 days of the reconveyance, my mother would need to schedule and pay for the next mandatory maintenance cycle, which ran approximately $2,800 for a property of that acreage. And there was one more thing. The county had, 14 months before the hearing, added the property to a new environmental compliance review list because of the road expansion project on the eastern edge. Any owner of a property on that list was required to participate in a compliance survey, which included a drainage infrastructure assessment within 18 months of notification. The notification had been mailed to me as the then current owner. I had received it. I had noted it in my property management file. I had not mentioned it to Richard Hollis because no one had asked me, and I was not required to advise opposing counsel on matters they should have found in their own due diligence. The compliance survey, if remediation was required, could run anywhere from $15,000 to over $100,000 depending on findings. The county had recently completed a similar survey on a property 2 miles down the road and ordered $47,000 in drainage infrastructure upgrades. Richard Hollis finished reading. He asked for a recess. The judge granted 15 minutes. I went to the hallway with Denise. She got coffee from the vending machine. I stood by the window and watched the parking lot. After a while, Denise said quietly, "He's calling a title company right now." I said, "Probably." She said, "He's going to be on the phone with the county drainage office in about 10 minutes. I said, "Probably." She said, "Claire, are you okay?" I said, "Yes." And I was. That surprised me a little, how okay I was. I had spent 5 years in a state of low-grade anxiety about that property, the next thing that would need fixing, the next payment, the next drive up, the next thing my mother needed that I somehow had to provide. Standing in that hallway, I felt none of it. I felt extraordinarily light. When we went back in, Richard Hollis approached the bench and spoke to the judge in a lowered voice. I couldn't hear most of it. I caught the words additional review and title search and timeline. The judge looked at him for a moment. Then she looked at me, or rather at Denise, as my representative. She said, "Ms. Denise, does your client have any objection to a continuance to allow the plaintiff's counsel additional time to review the property documentation?" Denise looked at me. I gave a small nod. Denise said, "No objection, Your Honor." The judge rescheduled the hearing for 6 weeks out. In those 6 weeks, Richard Hollis apparently did what he should have done before filing anything. He ran a full title search. He contacted the county drainage authority. He spoke to the environmental compliance office. He called the county assessor. And then he called my mother. I don't know exactly what that conversation sounded like. I can only imagine it based on what happened next, which was that my mother called my Aunt Patricia and cried for 2 hours, according to Patricia, who called me because she didn't know what else to do. I asked Patricia to tell me what she knew. Patricia said, She didn't understand about the drainage thing, or the county fees, or any of the survey business. I said, "Did her attorney explain it to her?" Patricia said, "I think so. I think that's why she's crying." I said, "What does she want to do?" Patricia was quiet for a moment. Then she said, "I think she wants to call it off." The hearing 6 weeks later was brief. Richard Hollis informed the court that his client was withdrawing her claim and would not be pursuing reconveyance. The judge noted the withdrawal. She asked if there were any counterclaims. Denise said there were not. My mother did not look at me when we left the courtroom. She walked out with my aunt on one side and Gerald's daughter, Sandra, on the other, and she didn't turn around. I stood on the courthouse steps in the November cold and watched them get into Patricia's car and drive away. Denise stood next to me and said, "How do you feel?" I said, "Like I've been carrying something for a long time and I just put it down." She said, "You still have the house." I said, "I know." She said, "What are you going to do with it?" I had been thinking about that for a while, actually. Since before the hearing, since around the time I understood that my mother was going to go through with this, that she was going to get an attorney and file a claim and sit across from me in a courtroom over a house that I had bled for, quietly, for half a decade. I had understood, somewhere in that process, that the house had stopped being about my grandmother a long time ago. It had become about something else, about whether I could be worn down, about whether the people who were supposed to love me most could take everything I gave and then ask for the container too. The answer, it turned out, was no. What I did with the house surprised some people, including Denise. I didn't sell it. I didn't rent it out or turn it into something profitable. I completed the drainage easement maintenance on schedule, as I always had. I participated in the county environmental compliance survey, which found that the drainage infrastructure was in acceptable condition. 5 years of consistent maintenance will do that, and required only minor adjustments that cost just under $4,000. I paid it without complaint. And then I drove up on a Saturday in February, the kind of cold, gray Ohio Saturday that makes the sky look like poured concrete, and I walked the 11 acres alone. I walked through the back field where the wildflowers would come up in April. I walked around the barn and smelled the hay. I stood on the porch and put my foot on the third board from the left and felt it creak under me exactly as it always had. I thought about my grandmother. I thought about her hands, which were strong and capable and never still. I thought about what she had built and kept and passed forward, and I thought about what I had done with it. I had kept it. Through everything, I had kept it. My mother called me a few weeks after the hearing. Not to apologize exactly. My mother doesn't apologize in direct ways. She called and talked about the weather and asked how I was eating and said that Patricia had mentioned I'd completed the drainage maintenance and she was glad to hear the property was being taken care of. And then she said, quietly, before we hung up, "I know things got complicated." I said, "They did." She said, "Dorothy's daughter said Richard charged her a lot for all that extra work he had to do." I said, "I imagine." There was a pause. Then she said, "I didn't know about the drainage thing." I said, "I know, Mom." She said, "You did know about it. It wasn't a question. It was something between an accusation and an acknowledgement, the way my mother has always operated, communicating sideways when direct feels too exposed." I said, "I did. I've known about it for 5 years. I've been managing it for 5 years." She was quiet. I said, "That's what I was doing, Mom, the whole time. That's what it looked like." She didn't say anything for a long moment. Then she said, "Are you going to keep the house?" I said, "Yes." She said, "Good." And then, after another pause, "Your grandmother would want that." I said, "I know she would." We hung up and I sat for a while with the phone in my hand. It wasn't reconciliation. It wasn't the conversation I might have scripted if I were writing this as a story with a clean ending. But it was something. It was my mother acknowledging, in the only way she knows how, that the thing I had been doing was real, that it had mattered, that walking away from it had cost me something, and that she had, somewhere in the process, understood that. I don't know what comes next between us. I think it will be slow and sometimes frustrating and probably never entirely uncomplicated, because that is the nature of my mother and me. But I know what I have. I have 11 acres in central Ohio and a barn that smells like hay. I have a porch with a board that creaks in the third spot from the left. I have receipts and county maintenance records and a deed with my name on it. clear and uncontested. I have my grandmother's house, and I have the knowledge, which I carry quietly and do not need anyone else to confirm, that I earned it. Not because someone gave it to me, not because I fought for it in the way people expect fighting to look, but because for 5 years I showed up, and paid, and maintained, and documented, and did not stop even when no one was watching, even when no one was grateful, even when the person I was doing it partly for was on the other side of a courtroom trying to take it back. That is what ownership actually looks like. Not the deed, not the name on the paperwork, the maintenance records, the receipts. The Tuesday mornings you drove 3 hours because something needed doing, and you were the one who knew how. I think about what Richard Hollis looked like reading page 7 of that deed. I think about the particular stillness that came over him. And I don't feel triumphant about it, exactly. What I feel is something quieter. The satisfaction of a thing that was always true finally becoming visible. The drainage easement was always there. The obligations were always there. The years of work were always there. All that changed was that someone finally had to look at them. If you've ever been the one who shows up, the one who manages, the one who keeps the thing together while everyone else assumes it's just staying together on its own, you already know what I'm talking about. You know what it costs, and you know why you do it, and you know, even when it doesn't feel like it, that it counts. It is all being recorded, somewhere. In county maintenance logs, in bank statements, in the memory of every contractor who showed up and found a woman who knew exactly what she was talking about. It counts. Every bit of it counts. And someday, maybe when you least expect it, someone will flip to page 7 and learn exactly how much.